Patents are a form of what is called intellectual property, and the reasons why patents exist is the notion that it is to the advantage of society to protect innovations. What a patent does is it gives an inventor, someone who has, for example, invented a new technology or developed a new medicine, the right for a certain period of time to exclusively exploit his or her invention. A patent is not a property right like other property rights. It is what is called a negative property right. What it means is that it gives you the right to exclude others from using your invention. It also gives you the right to give others the right, of course, to use your invention, which happens in the field of medicines when drug companies, for example, license their medicines patents to an organization such as the Medicines Patent Pool to make sure that those medicines can be made available at low cost in low and middle income countries, in developing countries. What patents do is it prevents generic competition in the market. It creates a monopoly for those who hold the patents, and with that monopoly, that holder, often mostly a drug company, can determine the price they want to ask. That is why you see an enormous discrepancy between the cost of production of a medicine, which can be very low, and the price of a medicine. Some of the newer medicines that go to market for over 100,000 euros per patient per year, for example, may cost only a couple of hundred to make. If there weren't any patents, the price of that product would be closer to 100 than to 100,000. And that is what patents do. This is also why they cause conflicts, because clearly medicines prices that are that high, that monopoly pricing of medicines leads to a situation in the healthcare system that it becomes increasingly difficult to pay for such medicines. And that is why there's also pressure on governments to intervene when companies are asking unreasonably high prices. Well, you have to, in order to obtain a patent, you have to apply for one. And you apply for a patent with a patent office, such as the Octrooibureau here in the Netherlands. You have to show that you have a real innovation, that it is innovative, that it is new, that it doesn't exist. You cannot obtain a patent on existing knowledge. In some countries, you can also not obtain a patent on an existing compound. That is not the case in the Netherlands or in most European countries. You can also obtain patents on new use of an existing medicine, for example. You have to apply for the patent. If your patent application meets the patentability criteria, you then get a patent that lasts for a minimum of 20 years. After that 20 years, if your patent indeed has led to a registered medicine, you also have the opportunity in the European Union to apply for a 5-year, maximum 5-year extension of that patent, and that can even be extended under certain circumstances. So that is one way of obtaining a patent protection. Now, this sounds a bit as if this is all one person or one entity doing that, but what happens in practice is that the early knowledge that ultimately leads to a registered medicine is developed often in research institutions or in universities. And then that knowledge is transferred with the patent to a commercial entity such as a pharmaceutical company for further development and to apply for the marketing authorization of a medicine, because a patent does not give you the right to market the product. It gives you the right to exclude others from using your invention. But in order to bring a medicine to market, you also need the authorization by medicines regulatory bodies, such as the European Medicines Agency, for example. And that is a different set of requirements. You get that authorization if you can show that your medicine is effective for what you say it is effective for, and that it meets quality criteria and that it is safe to use. Once you have that, you can bring your product to market. That medicine's regulatory system also provides certain exclusive marketing rights because you have submitted clinical test data, for example, that will then be protected for a certain period of time. What that means in practice is that a competitive product by a generic company cannot obtain a marketing authorization from that medicines agency. So that is a different set of exclusive rights that come on top of the patent rights. You can also, of course, obtain market authorization for a medicine without there being any patent. But this was just to say that the sort of patent life cycle may have different holders throughout the existence of the medicine. Now, after the expiry of the patent, that knowledge falls in the public domain and others can start using that knowledge and make their own versions of the medicines. And that is the moment when those products go to market. That is where you see the price of a product decline, often dramatically, because as I explained earlier, the actual production cost of a medicine can be very low. The cost of bringing a product to market really sits in the research and development phase, which can be very expensive.